Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book which has come to us from Oxford University Press. It's an excellent book. It's called European Cross Border Insolvency Law, being written by Rheinhard, Bork and Renato Mangano. Now, the book's a hardback. Elizabeth and I have given the title of our book review the following: The Cathedral of the EIR, a European approach to cross-border insolvency law. Now, we wrote this review prior to Brexit, so I don't know what is going to happen in the future, but the book is current, it's a first edition, and I'm sure whatever happens, there will be probably a new edition and there will be changes as Britain prepares to leave and do its own thing internationally. Now, there is the front cover of the book. There is the spine, there's nothing on the back. It's a hardback and it runs to something approaching 300 pages, just over. Its index at the back is by paragraph numbering, so you can find things. It's a useful index, quite detailed. There's a very good bibliography, very much the house style of OUP coming through here. A lot of information that's available. Right at the back you can see the way it's done. There's the paragraph numbering I talked about. There's a little bit of footnoting, and then there's some literature references at the back. That's of the last chapter, chapter 8. If we go to the front of the book, you can see the front cover there. Then you can see there's a nice dedication, which I shall just show you there, which the authors have put in. Then there's a preface. It's well worth reading. It's looking at EU regulation, of course, and it then runs through. Dated July 2015. I'm recording this in July 2016, where we've been through a constitutional crisis in this country and got a new Prime Minister and lots of changes. There's the front contents section there. I don't know that things will change that much, anyway, initially. You can see the 8 various chapters. The contents is quite detailed, so you can find things, I think, pretty quickly by cross-referencing the contents or the index. There's the table of cases, then some legislation, of course, and then after that, I think a very useful list of abbreviations. Can I just mention with the table of legislation that you've got the European stuff at the back, all of which is relevant still and will be for some time. List of abbreviations, very helpful in this area of law, as you can see. Lots and lots of lovely abbreviations, some of which I've got absolutely no idea what they mean, so it's very useful to have this, so you've got some idea of what they're talking about, and also how to actually pronounce some of the abbreviations as well. Now, there is the introduction there, and then it starts off cross-border insolvency. Then you see quite quickly you've got a lot of quite detailed footnoting, and then in the middle of it international jurisdiction. Very important, because whatever one's views about where we are at the moment, middle of 2016, on the future, either within Europe or outside, we are in a global community. Whether that's markets or whatever it is, it's the same for insolvency issues. It's not something that's now very much limited to borders, so we have to see where we're going. Now, let me just tell you what we think about this particular book. Practitioners in general, and certainly international and comparative lawyers specialising in cross-border insolvency law across Europe, will welcome, we think, this new book from OUP, the Oxford University Press. Do have a look at our review, which is in the journals and on the web. But this is what we said. Basically, the book is a detailed examination of European insolvency law, and it analyses the issues of and intricacies of the new European Union regulation dated May 2015 on insolvency proceedings. That's the EIR as it's known, which has recast the former EC regulation of the year 2000. As I've said, whatever we have to happen in the future with our removal, our withdrawing from the European Union, the directives will be there for some time, so we have to see where we go. And I'm sure these books will be rewritten relatively quickly, I would have thought, as we dismantle everything. It's going to take a huge amount of legal work, no question about that, for the foreseeable future. So it's in this new regulation, the EIR, which aims to tackle the issue of cross-border insolvency cases involving at least one EU member state except Denmark, while also taking into account certain relevant documents prepared, for example, by UNCITRAL, the United Nations Commission on International Trade Law. Now, I call it UNCITRAL because I think it's the easiest way of describing it. In case you need reminding, obviously, it's an important, very important UN organisation. And as I said, the alphabetic list of abbreviations does come in very handy at the front of the book, because some of them I've just never come across before, and I'm sure many people haven't, so it is useful. Related sources of hard and soft law are covered, together with the relevant codes of best practice, which, in aiming to improve cooperation between insolvency practitioners and the relevant courts, offers the expectation of a significant improvement in quality over the previous EU regulation. And I think that's the important thing to bear in mind, because one of the things I'm suggesting, and I'm sure a lot of other people are, there are lots of things within what we've got at the moment in our framework of law linked to the European Union, which we want to keep. So let's keep the best bits and get rid of the bits we don't like. And obviously one area has got to be cooperation. Let me go on though. Especially useful, I'd suggest, from the point of view of the reader, is the author's emphasis on providing what they've referred to as a view from the cathedral of the EIR. In other words, here you will find an analysis of the role of the Court of Justice of the European Union, the CJEU, in the interpretation of European insolvency law, as well as its judicial activism. I'm going to say another thing here, and that is that our withdrawal will affect that. So we will have more of a persuasive rather than a mandatory precedent in what they say. Now that is what I always thought we actually had until we had things like the Lisbon Treaty. But that has been the issue, and that is where we're going. So bear that in mind with this book. And the authors, who hail respectively from Hamburg and Palermo, note that the book endeavours to answer three fundamental questions on cross-border insolvency cases as follows. A, which member states have jurisdiction, what laws are applicable, and if a member state has already made a decision concerning an insolvency case, would it be possible for this judgment to be recognised in another member state, and how might this happen? Again, as I said before, these are issues we're going to have to look at, but just looking at that at the moment, there's no reason to suppose, although I'm an arch Remainer myself, there's no need to suppose that we can lose all this stuff by leaving the EU, because some of it's eminently sensible. And as I've said before, we should cherry pick the best bits and keep them. Now, European insolvency law, the authors add, is a fairly recent topic which enjoys no long-standing historical background. This, of course, is all the more reason why insolvency practitioners should acquire this book, which deals exhaustively with the subject matter. Not only does it comment on the scope of the EIR, it touches on a range of other issues, including secondary insolvency proceedings and group insolvencies. That said, the authors are careful to point out that the book does not aim to establish a benchmark for evaluating the EIR, or to offer a new appraisal of European insolvency law. The, at least partial objective, is to explain the system of the EIR to both academia and practitioners, to provide satisfactory answers to the above questions, and of course much more. And as I've said before, this subject is bound to crop up as we prepare Brexit, and so this is an area which we will have to look at carefully. Fortunately, the book is organised for ease of use, as it contains a detailed table of contents, comprehensive index at the back, and a no less than 9-page bibliography, which contains rather a treasure trove of references for researchers, who will also value tables of cases and of legislation which encompass statutory instruments, the European directives and legislation, as well as international instruments. So let me conclude by saying yes, as the topic of cross-border insolvency is a relatively recent one and going to be the subject of further substantial change, I would suggest, this book will no doubt be recognised as a valuable addition to the professional library, particularly those of insolvency practitioners. And the law is cited as at July 2015, and of course we're now a year down the line. Here's the book again, briefly, the spine, and then the back. There's nothing on the back. Then, as I say, you've got the index, and then you've got, I'm just looking at group insolvencies and cooperation, chapter 8. You can see again paragraph numbering and, of course, the footnotes. Secondary insolvency proceedings. And again, I think one of the points is whether we're in or out of the EU, we still got to have some agreement. And it may well be that we are fashioning, as we move towards the middle of the century, we're going to be fashioning a whole range of new types of agreement. And perhaps the stagnation that some parts of the EU have fallen into may be sort of dealt with. It's an aspiration. But there again, thank you to the authors, Rheinhard, Bork and Renato, Mangano and OUP for another excellent title. It's well worth reading. Bye-bye.